Apple Inc.'s plan to halt online sales of its smartwatch 4 days before Christmas to comply with the regulator's order shows that it's an illegal jam. And the company has known for almost 2 months that a ban imposed by the International Trade Commission would take effect December 25th unless it persuaded the Biden administration to intervene or worked out a settlement with Masimo Corp, the medical device maker that accused it of copying patented technology for measuring blood oxygen levels. The iPhone maker now is racing to make software fixes in a workaround effort to get the product back on the market next year and salvage the $17 billion business generated by its smartwatch sales. The company's preparations to pull a big moneymaker off the market in the busy holiday season signals that its prospects for relief for the ban are dwindling. And intellectual property lawyer James Gajan said it's striking that in its long-running dispute with Masimo, Apple hadn't begun the process of obtaining approval for alternative designs earlier or made other arrangements to avoid a halt in sales. Normally we would want to have a fallback position so that we could ensure some continued supply, said Gajan of the firm Allen and Overy LLP. But patent disputes of the sort that arose between Masimo and Apple in 2020 typically settle before they get to the point where one side is facing a potential sales ban. In this case, Masimo's allegations of wrongdoing ran deeper than patents. The Irvine, California-based company accused Apple of poaching its employees and stealing trade secrets, worth $1 billion, which the iPhone maker denied. A jury trial this year ended in a stalemate. That Apple still can settle with Masimo, though it's a route that the Cupertino, California-based giant typically prefers not to take. Bloomberg Intelligence has estimated that after Masimo gained leverage with its victory at the Trade Commission, and it can negotiate with Apple for a multi-year license in the range of $60 million to $300 million in annual royalties. Apple has proposed a redesigned smartwatch for review by a branch of the U.S. Customs Agency. And according to November legal filings, but Tamlin Basin, BI industry analyst, as we said, that Apple's request for the ITC to put its ruling on hold and for an expedited opinion on redesigns for a blood oxygen sensor were long shots. Representatives of Apple and Masimo didn't respond to requests for comment. Apple has said the ruling from the ITC is erroneous and that it plans to appeal. The ban demonstrates that even the world's most powerful company must abide by the law, Masimo has said. Its chief executive officer, Joe Kiani, has said Apple has tested updated Masimo technology that could, if licensed, resolve the patent infringement. Apple has a few days left to persuade the White House to overrule the ITC ban, but such vetoes are rare. There's been just one in the last decade. When the Obama administration in 2013 halted an iPhone ban stemming from a patent dispute with Samsung Electronics Company. The fact that the only White House veto issued in a decade was in Apple's favor might have given the company the impression it could clinch a political victory after a judicial loss, said Nicholas Matish, a former acting general counsel for the U.S. Patent and Trademark Office. Apple may be feeling a little bit of invincibility, said Manick, who is now at law firm McCool Smith PC. And if you see it, Matish doesn't think Apple's on a dead end. A software workaround seems like a viable strategy to rescue its product without making concessions to Masimo. He said, and the patent suit pertains to one very specific feature of Apple's product. He said, Apple can remove the feature and then it's not infringing.